Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here on this Friday. Hope everybody's ready for the weekend. We're going to jump into our music fact of the day because we have a lot to cover. Along with Buddy Holly, Ritchie Valens was one of the first guitarists to play on a Fender Stratocaster. Pretty cool. I love Buddy Holly and Ritchie Valens. The Buddy Holly story is a great movie if you haven't seen it. Real quick update about Lori Vallow. She has a new attorney, Craig Durham, who will be handling her appeal. He has filed an amended notice of appeal. I'm going to go through that on the next episode. I just didn't get around to it today. It's not different in a big way from what was originally filed, but we will cover that. A lot of people asked if I would cover the Brooks Houck hearing from yesterday. He had his arraignment, and boy, did they drop a bombshell flat in the middle of that hearing. We're going to get to that in just a minute. Brooks was on video. He was not present in the courtroom. The courtroom was full of Brooks's family, Crystal's family. It didn't seem like there was an empty seat in there from what I could see. His attorney waived reading of the indictment and also entered in a not guilty plea on his behalf. The state says discovery in this case so far is around 1 terabyte, and they've turned over 129 gigs before the hearing started. Some of the discovery is interviews, grand jury testimony, photos, as well as subpoenas. They said both sides have talked about how they will handle discovery and that they have a system in place that they think will work for both sides. The state is in the process of redacting thousands of pages of discovery, but we'll get that to them. The judge also suggests they number the pages so it makes these hearings go smoother, and they all agreed. The state said as far as a trial goes, their case in chief would take about a week. Neither side wants to set a trial date just yet. They've agreed a pre-trial hearing in February would work, and then they would go from there about setting a trial date. The judge asked both sides if a summer trial date would work. His defense attorney said they don't think they would be able to adequately represent Brooks at all in 2024. They have another case with 1 million pages of discovery and don't think they'll be ready. He didn't specify if he literally meant 1 million pages or if that was an exaggeration, but you get the point. The judge wants the trial to be set for the end of whatever month works. He said July is perfect for him personally, and the defense says they plan to file a motion at some point for a change of venue. They say the pretrial conference shouldn't take long. The defense says they'll probably come in and say, we need another date set. So right now, they have tentatively set that pretrial conference for February 8th of next year at 1 p.m. local time. Now they discuss bond. The defense talks about the presumption of innocence and protection against excessive bail. The defense attorney says the grand jury out of Nelson County actually were the ones that set this bond. And in over 20 years, he has never seen a bond this high or even in the same zip code as this. He says the court has to look at different statutes. He cites a recent one that was passed that says the court must look at pretrial services reports and determine if the defendant is a low risk, a moderate risk, or a high risk for being let out on bail. Kentucky says if a defendant is low risk, no cash bond would be needed. A moderate risk, the court should consider if there's conditions to the release to ensure that defendant stays in the jurisdiction and also that the community is safe from danger. Brooks was evaluated, and the defense says his risk for not appearing is low. He got 1 point against him, and that was from a 2012 for a no-show for a motion to show cause for a traffic ticket. The appearance probability for Brooks is 87%. The court also assessed if he would be arrest-free while trial is pending. He got low risk on that. He met no criteria the court set forth. The defense says this is the same chance as a tornado hitting the courthouse as far as whether or not Brooks would be arrested while out on bond. He points out the number of people in attendance there to support Brooks. And in 2015, he says police named Brooks as a suspect. They released things to the media, and he's known for 8 years that he was on law enforcement's radar. And when he was arrested, he was at a job site doing his business a week ago. He's been the subject of media stories, and he points out there's a billboard near the courthouse about the case, and he still hasn't fled the jurisdiction. He says that Brooks has known forever that people were saying bad things about him, and yet he did not run. He told police from day one, I had nothing to do with her disappearance. This is where my family and business is. I'm not leaving. The defense attorney also mentions that Brooks's son, his family, and his business is here. there's no reason for him to leave. He said it's a fanciful speculation that he's a flight risk, a danger to the community. All the government can use is this case. He has no violent history and no criminal convictions. And when the FBI arrested him and released a statement to the media, one thing they said was he was arrested without incident. He didn't run, he didn't fight, and he submitted to their authority. Is the bond oppressive? I say 10 million bond is oppressive. I tried to look at other homicide cases here and in other counties and also around the state. I looked at high-profile murder cases and people from prominent families. He said one that struck him was Commonwealth versus Ricky Kelly, which was a case out of Louisville, Kentucky. Mr. Kelly got a lot of media attention. He was alleged to be an assassin. I don't know if it's true, but heavy media attention was focused on that case. Mr. Kelly was indicted for 8 murders, robberies, and assaults and bragged about it over jail calls. His bond was set at $1 million. Then he talks about the son of a millionaire who laid in the bushes and killed a UK football player. The dispute was about the defendant getting kicked out of a fraternity. The bond was $1 million. Today's rate would have been about $1.7 million. Then he refers to a gang leader in Louisville who was charged with 3 murders, assaults, intimidating witnesses, and also the death penalty was sought in that case. He said that was the highest bond he could find, and that was set at $3 million. He said if Brooks could pay $10 million, he would, but he can't. The most important thing to consider, bond isn't to punish a citizen before he can resolve the case or have a trial. If he sits in jail on a $10 million bond until trial, his business will fail, his son will be without a father, and he won't be able to assist in his defense. The grand jury set this bond to ensure Brooks can't make this bond. It is to ensure the defendant will comply with the court's conditions. He has no violent offenses, and most importantly, he knows if he were released on $1 or $10 million or $1 billion bond and he breaks the terms, he will go back to jail, and that's the very thing Brooks doesn't want, as well as his family or his attorneys. We're not asking for special favors or conditions. We ask bond be set just the same as similar cases, defendants with no violent history. So the defense asked for a $500,000 cash bond with GPS monitoring so that Brooks can go back to work. The state says the Ricky Kelly case, he pled guilty to manslaughter because the witness in that case had been killed. Murder is a capital offense and he could be held without bond. Defense counsel doesn't know if there are aggravators in this case or not. The state says we didn't ask for no bond, but we asked for a significant bond. I've never asked for this high of a bond. The defendant bears the weight of the indictment. Some of the jurors thought that bond should be set at double that, putting that figure at $20 million. The defendant has a loving family, and I'm going to come back to how loving that family is. And that was a little hint at the bombshell that was dropped a little later. In order to ensure compliance with the court, he deserves a $10 million bond. Brooks has vast resources. He solely owns 3 separate companies with substantial real estate holdings. These companies were established in 2007, 2013, and 2022. The real estate holdings from all 3 companies were printed off by the state. The combined tax assessment from the properties of those 3 companies is $8.4 million, and that doesn't include 12 other pieces of property the state could not find tax assessments for. It doesn't include the property his mother and sister resides on also. Brooks has 74 rental properties, which he gets monthly payments for. Doesn't include any wealth from his bank account, including the 2018 sale of properties that totaled $1.8 million. His situation is different than the cases the defense mentioned. $10 million is a fair bond for somebody that has these resources. $500,000 is not a lot of money when you may spend the rest of your life behind bars. And he says this about influencing a case, meaning that $500,000 is not a hefty figure if you want to go out and try to influence your case. We ask the courts to consider the defendant and his family's behavior during the grand jury proceedings. The defense talks about the love and support of his family, and I agree. They've been supportive. His sister Rhonda, his brother Nicholas, mother Rosemary, and her live-in boyfriend Larry, his brother-in-law, Alex, secretly brought in recorders and recorded the grand jury. I've been practicing here, Your Honor, for 25 years in this state, and I've yet ever heard of anyone recording a grand jury. That's huge. I'm wondering if some of Brooks's family isn't going to be arrested. The state goes on to say, I've got copies of the grand jury proceedings, and I will tell your honor, I also have a transcript. This is an in-house transcript that has conversations with times on them that occur between them. The total time of the tape recording is 5 hours. The first 2 hours are communications between Brooks and his sister, where Brooks shows her how to record and tells her he wants a tape of the grand jury proceedings. The question is why? I think everyone in this courtroom knows why. To be sure, everyone's story is consistent. The truth will imprison Brooks. We asked to keep the bond the same. Recording a grand jury proceeding, by the way, I looked it up in the state of Kentucky, can result in a contempt of court charge, and a person who is found to be in violation could be fined between $500 and $1,000 and be imprisoned for 6 to 12 months. Yikes. The judge said the one thing the court is concerned about is to ensure appearance and to keep witnesses safe. Are there any other investigations going on? So the state says, we're investigating the murder of Tommy Ballard, which is Crystal's father. We know he was shot while hunting with his grandson. He said, we are waiting for testing to come back on the gun that was used to murder Tommy Ballard. The gun we purchased from Brooks's brother, Nicholas. Remember, Nick was the cop who was let go of his duties due to interfering in the investigation into Crystal's disappearance. Not only that, they purchased the gun from Nick. It seems like maybe this was an undercover thing. And by the way, Nick was using a fake name when he sold the rifle. The state says they know it's the same caliber. There are 5 criteria that's used, and so far, that rifle has matched 4 of the 5. We would ask if the court does grant bond, I will provide a list of witnesses, and we would ask for GPS monitoring, no contact by Brooks or any of his family to those witnesses. The defense says they don't object to the no contact, that's standard, and they don't object to GPS. The defense attorney goes on to say, I can't address everything he stated about the facts of the case. There are 2 ways to look at the recordings. As the defense says, you want to know what's being said because you did something wrong. The other way to look at it is law enforcement comes out and says you're the prime suspect and releases evidence, and that's put on podcasts and true crime TV shows and in the media, and who in their right mind wouldn't want to know what's being said? That's not a condition of bond. It's kind of also illegal, so you might want to know what's being said, but you might find yourself facing some charges in the meantime. So the defense says that the state mentioned something about their investigation into Brooks' brother Nick, but that's not Brooks. We don't set bond for one family member based on speculation that another family member did something wrong. He said in this case, they're handicapped because his business will fail. We can say if they find him guilty and his business fails, then we say that's a consequence of your actions. But if he's found not guilty and his business fails, that is a taking of epic proportions and destroys his livelihood and his life prior to any decision whether or not he's guilty or not guilty. The defense says the state talked about whether or not this is a fair bond. He said $8 million in tax assessments on properties. The problem with that is you can't post a property. You would have to go to a financial institution and try to get a loan. $8 million, by the way, is not $10 million if you could even get a loan for that. If you borrow that at 8 to 10%, that's $800,000 a year just to service the debt. That is by definition under the Constitution excessive and punitive. There's no capital offense charged here, no aggravating factors, and he conveniently left out if you try to hold someone without bond, it's on the Commonwealth to present significant evidence as to why there should be no bond. He said the grand jury recommended more bond. The grand jury is presented with one side of the story. The state decides all things regarding a grand jury with no witnesses being subject to cross-exam. The grand jury is made up of citizens with no extensive knowledge of the judicial system because they're not in the courtrooms like we are every day. They don't see other cases, and they don't know what a typical bond is in a murder case. So ultimately, the court will take that issue under advisement. He has to review what was submitted to him during that arraignment yesterday. Just of note, Tommy Ballard, which is Crystal Rogers' father, he was killed 16 months after Crystal went missing. He was hunting with his grandson, and his wife said in November of last year, I don't want anybody to forget what happened to my family and that we're still looking for answers. If he wasn't out physically searching, Tommy was on the computer looking stuff up. He promised the kids he would bring their mom home, and he never gave up on that. It's very hard for me to sit and wait, but I know the end result is going to be worth it. So I sit and I wait, and I think if they find who was guilty for Crystal, I think they have justice for Tommy too. You might be right there. So, big bombshell. I mean, we've always heard speculation, and I don't talk about speculation, but in this case, it's okay, that his brother Nick may have been involved in some capacity. And yesterday, the state let it out there that seemingly through something undercover, they bought this rifle from Nick, who was using a fake name to sell that rifle. I think we're going to see more arrests in this case, more than one, maybe, but we will see. Not an attorney, just my 2 cents. Moving on to Keefe D. I was reading his book. I found a free copy of it. I'm not going to buy it, but there were some things in his self-published memoir that incriminated him in the murder of Tupac, or he incriminated himself, rather. Investigators have said he was the shot caller for the murder of Tupac, and in his book, he talks about going to Vegas for that Mike Tyson fight on September 7th, 1996. That's the night Tupac was murdered at the MGM Hotel. We know his nephew, Orlando Anderson, was attacked after the fight by Suge Knight and Tupac. This was all over a necklace. There was a monetary reward for taking a very distinct Death Row Records necklace that was given to the elite within Death Row Records. I have a photo of that necklace on the screen. That necklace was ripped off of somebody who was recording under Death Row. And he says he was told by gang members that his nephew had been jumped. We couldn't let no record company, studio gangsters do us like that. They've lost their effing rapping minds. Them jumping on my nephew gave us the ultimate green light to do something. Tupac chose the wrong game to play. Keefe D said he already agreed to help the East Coast rivals of Death Row Records, but didn't go to the fight intending to have any trouble with Tupac that night. But he says after the beating, it got personal. Keefe D names a man who I will not name here because law enforcement has not, brought Keefe D into his Mercedes and showed him a gun, allegedly telling him it's time to get the money. Tupac was supposed to go to a post-fight after party at Club 662. That club was backed by Death Row Records. Well, Tupac didn't show up to the club for an hour and a half. In the meantime, Keefe D and 3 others waited in the back parking lot of that club for Tupac to come outside. Now, in his book, he said there were no need for words. We all understood why we were there. After they waited for an hour and a half, Keefe D told his men to leave. They all were headed to a liquor store. And as they sat in traffic, he said, we slowly rolled past the long line of luxury cars they had in their caravan, looking into each one until we pulled up to the front vehicle and found who we were seeking. They happened to see Tupac in Suge's car. Tupac was hanging out of the passenger window. He was responding to fans that were yelling his name. Keefe D said the car he was in, which was that white Mercedes, did a U-turn and pulled up beside Tupac's car. He said he saw what he thought to be Tupac reaching underneath into the car to grab what he thought might be a weapon. And then he said, quote, then the fireworks started, end quote. One of my guys from the back seat grabbed the Glock and started busting back. As the rounds continued flying, I ducked down so I wouldn't get hit. Keefe D, as we know, also gave interviews where he said his nephew Orlando shot Tupac 4 times in the chest. Orlando always denied being the shooter, and just of note, we've talked about this, Orlando was killed just a few years after Tupac. He said after the shots had been fired, they took off in that Cadillac. He said, I don't know why the Vegas police did not check Tupac's hands for powder burns to see if he was shooting, because the car they were in was shot the F up. I don't understand why people act like Tupac was an angel. Keefe D and his men ditched that Cadillac and decided to walk back to their hotel. As they were waiting to cross Las Vegas Boulevard, they actually saw the ambulance that was carrying Tupac fly by. He said his crew proceeded to go back to their hotel and, quote, pop our bottles and partied like it was any other night, end quote. The moral of the story, he says, real gangsters are nothing to F with. For us, Vegas was another day at the office. It may sound cold-hearted, but from a street perspective, the killings of Tupac Shakur and later his rival Biggie Smalls would be considered nothing more than collateral damage. The next day, they got the Cadillac and returned to LA, where that car was cleaned, painted, and then returned to the car rental agency days later. He said at that point it was too late for any forensics to be accurate and reliable. They could have got some gunshot powder from the inside for sure. He did say he had deep remorse for Tupac's murder, but he also said Tupac and Biggie's deaths were direct results of that code violation and the explosive consequences when the powerful words of the street, entertainment, and crooked law enforcement collide. We talked earlier in the week about that proffer that Keefe D gave years ago, where investigators asked if he would give information and in return, he would not be charged for doing so. In his memoir, he said, "I sang because they promised I would not be prosecuted." Now, Keefe D did an interview earlier this year with DJ Vlad, and he was asked if he was worried what he told investigators could ultimately land him in prison for the rest of his life. Keefe said, "They want to put me in jail for life. That's just something I got to do." Now, video of his arrest has been made public as of yesterday. He told officers who got out of unmarked cars to take him into custody, "I don't give a crap and I ain't worried." When he was told to have a seat in the car, he said, "I'm a pro, dude. I got it." It takes one of the officers kind of by surprise, and he repeats it. He said, "I'm a pro." All right. Tupac's stepbrother, Mopreme, said, "We've been through decades of pain. They have known about this guy who's been running his mouth for years. So why now? For us, this is not over. We want to know why and if there were any accomplices." And as we know, just throwing this out there, Suge Knight and Keefe D are the only two surviving witnesses of that shooting that night. Whether or not anybody else knew who was not present, maybe we'll learn that at trial. Keefe D in the arrest video said he was thirsty and wanted water as he was being checked for weapons and handcuffed. Members of the grand jury were shown photos of Tupac dead in the morgue to combat any conspiracy theories that he may have faked his death. If you followed this case even for half a second, you know that was one conspiracy theory that really started the day after Tupac was murdered. People thought he faked his death. He's living somewhere just for his own safety. They were also shown bullet wounds and photos of stitches where doctors opened up Tupac to try to save his life. So there you go. It's going to be an interesting one to watch. Moving on to Shanna Gardner, the ex-wife of Jared Brodigan. He was killed in 2022 in Florida after dropping off his children with his ex-wife. Remember, he had his child in the car at the time. She's facing first-degree murder charges, conspiracy to commit murder, solicitation to commit a capital felony, as well as child abuse. She was arrested in Washington State, as we know, and her extradition warrant was to be sent to Florida, and it was signed by Governor DeSantis on September 13th. The judge in Washington postponed her hearing yesterday so the state could have time to receive those extradition papers, and Washington Governor Jay Inslee signed a warrant to extradite her on October 3rd. The next extradition hearing is set for October 19th to give the judge time to receive the warrants and also for the defense to file anything they need to before that hearing. The state attorney's office in Florida says there's no set timetable for when she'll be extradited or when she will actually arrive in Florida. So that's all we know about that, but she's sitting in jail. No harm, no foul. She'll get there. Moving on to Craig Ross Jr., who is believed to have kidnapped Charlotte Senna. Investigators don't believe anyone else was involved in the abduction of Charlotte, but they are looking into whether or not his mother might have known he did. They share a property together, if you remember. We kind of laughed about this on the last episode. When you have family members that return home and you don't want them in your house, you stick them in a trailer on the back of your property. And New York State Police Colonel Richard Allen said his mother has been interviewed, and he said, "We are working with her and interviewing her, and as far as charges on her, it's too early to say what may or may not happen there. We're still trying to determine what she did know and didn't know at the time. We don't believe anyone else was involved in the abduction itself." He also said that we can expect more charges to be brought against Craig. He requested an attorney just a few hours after his arrest, so it doesn't seem like he's spoken to investigators. Charlotte was found in different clothing than she went missing in. If you remember, she went missing in a tie-dye Pokemon shirt. She was found in a sweatshirt. It's also been revealed that Craig was previously investigated for allegedly sexually assaulting a girl who was a family acquaintance when she was 12 years old. The incident is alleged to have happened over a year ago. Now, the allegations were brought forth over the past summer, and the investigation was closed with no charges being filed. His next court appearance is set for October 17th. As we know, he's being held without bail. So we're all caught up, y'all. I took the day off yesterday. I had some things to do, but we're back where we need to be today. So I will see you guys at some point this weekend with a new missing person case. Please share those episodes. I'm not claiming to have some huge reach with this podcast, but it takes one person to see a face, to hear a city or hear a circumstance, and it could jog their memory and be the break we need. It's a collective effort. We all got to bond together and get these faces and names and circumstances out there. So I will bring that to you at some point this weekend. In the meantime, have a good rest of your night. Have a good Saturday. We'll see you soon.